Hello, I'm Jason Leggett, and I am a law graduate of Seattle University. And today I'm going to be talking about what law means. And I'm coming from a perspective in the research community called law and society. So there's a few different ways of studying the law, um, and say within like the tradition of the United States or within the European tradition or the West. So kind of historically, folks have looked at the law as a structure, a place. You could think of it as a place. So people think about courts. Pretty regularly, I hear people talking about the law as the Supreme Court. Um, and there's, of course, nothing wrong with that. But it's not the only way that law is used. So another way that people, I think, usually think about law in their everyday life. So now I'm not really talking about people in the university system, but just ordinary folks. We tend to hear something like rights, or I need to get a lawyer, or I'm going to file a lawsuit, or I got a letter in the mail about the law, right? And then sometimes I think, interactions with police officers or other just people that work within the systems of government. So here we're thinking a little bit more about the instrumentalities of law, or how law is kind of circulating or used or accessed. And so here we're really thinking of law more as a tool. And then there's also, I think what's super interesting to me is this idea of law as being something that is within our language, something that we're trying to think about or access, or something that we use to have a conversation with somebody else about not so much the place like the court and not so much a lawsuit, but more of fairness, justice, injustice, rights, things that we are using from our personal basis or from our own experience, but that we think other people are probably going to have some connection to as well. And so these are ideologies, or another way is just ideas that we share amongst each other in our relationships. So I'm going to go through all three of these, and not to show that they're different, but in order to show how do they work together. So I kind of want to think about this from a more classical or a time from antiquity, right? So I'm thinking in this complicated history, this natural history that stems over 2,000 years, where have we in the United States received our ideas about what law is from? And so a lot of folks, I think, are aware that many of these traditions come from the Anglo-Saxon traditions within England over the last 1,000 years. But those ideas also kind of came from the Romans, and the Romans kind of got those ideas from the Greeks. And more I'm looking into the relationship between what the Greeks were looking at and how that related to the previous civilization and existing civilization of the Egyptians. And so you kind of see this concept of law, and in the Greek it's the nomos, as something that is not out there. It's not an object, it's not a thing, but it's a way of thinking, and it's a concept that people have used for a long time in very different ways. But from the point of view of either power, and so you think of a law that might come from a supernatural being like God, a law that comes from the rich, a law that comes from, I think of a Beatles song here, happiness is a warm gun, right? So a law that comes from violence, right? There's a lot of different ways that people have thought about that, about power. And then on the other hand, there's another side to that equation, which is the so-called powerless, right? The people who are being dominated, controlled, oppressed, used, manipulated, right? However you want to think about this, but there's somebody on the other side of this use of power. And so I think if I were to put this into the phrases of the Greeks, I think I'd say it something like this. And I'll call this a work in progress because it's a draft from something that I'm working on as kind of a practical manual for the use of law for ordinary folks. And I'd say something like, if we were to go out into Manhattan and look up at these giant skyscrapers, and we think about where is law in this case of the powerful, and I think we'd say something like, well, these humans, as if they were gods, are controlling our every move. From their mountaintops on the 50th, 60th, and I see even higher floors, they organize the earth for profit. Where are the angels and daemons who might negotiate on behalf of the powerless with these gods of power? And so if you've ever read Greek mythology, or there's a lot of movies and TV shows that you could experience as well, and even if you've never read or watched or heard these stories, I bet they're familiar to you. But in these stories, there's always some human being who is negotiating with the gods through quasi-supernatural beings in order to bring some sense of resolution to a conflict between other human beings and then, in many instances, other gods. And so I think this almost appears to be missing in today's society, and oftentimes students bring this up, is when will we have someone who can help us? And I think we're thinking about law as that something, right? A tool that we might be able to use to negotiate with those with more power. So I've constructed a diagram here, a model, and I think in the past I've used a triangle, but I think now I'm seeing through conversations with students, it's something more like a circle. And a friend of mine who I teach with has also thought of, we've thought about maybe as a structure of DNA, a double helix. It could also be a centrifuge from the concept of physics. I mean, I'm not sure exactly what the shape of the law is in this sense. But one philosopher or anthropologist, Bruno Latour, has talked about this idea of the political circle, right? Something that can get bigger, meaning more people can participate within it, or it can get smaller, right? Meaning more people get excluded from it. And so I do like this idea of establishing the jurisdiction, right? Something that, if you look at the 14th Amendment, citizenship and personhood is defined by being subject to the jurisdiction of. So any one of us that are here on quote-unquote U.S. soil, right? We're here within the United States. We are subject to the jurisdiction of the laws. More and more folks are finding out that they are subject to the jurisdiction in an interaction with a public official, whether it's a bureaucrat at the DMV, or whether it's a tax official, or whether it's a police officer in the street. We find that we are subject to the jurisdiction. So this is a lot less relatable to the concepts of the past that I was kind of drawing from Greek and Roman culture, where citizenship was defined by blood or allegiance or military participation. This is more into the networks that we have with other human beings and our relationships with each other here in this space. So I do want to start with this kind of basic idea that comes from Linda Metcalf's book, A Quest for Legal Sovereignty, in the chapter A Quest for Legal Sovereignty, and her book is called Law and Identity. Lawyers tend to speak about law, sovereignty, jurisdiction, power, when we think about acting like a government. So in other words, because we have interactions with people in the government, and we see power, authority, and law through those officials, we aren't necessarily recognized as being powerful unless we are also acting like a government. Now here I'm not really talking about an individual. I'm talking about you within your social group. And people define social groups many different ways. In Metcalf's book, she's looking at American Indians, particularly on reservations. And reservations are physical places that have been negotiated with the United States government to have a certain amount of what's called quasi-sovereignty, a certain amount of independence from involvement, interaction, and interference from either the United States government or the state government. However, this is rarely, recognized in day-to-day interactions between human beings, right? So people go onto the reservation or try to utilize resources from the reservation and vice versa. And I'm sure you can think of lots of examples from the news and from popular culture. And so I think what we're seeing here is that if I don't want someone to interfere with my social group's independence, I need to have some structure and organization of my members of my group in a way that the government can recognize our power. This concept of acting like a government comes directly from the idea of speaking law, which has a Roman or Latin basis called jurisdiction, right? We combine those two words into jurisdiction, but jurisdiction is to speak the law. And that concept comes again from the Greek concept of nomos. And nomos is a little different, though. Nomos was the negotiation tool that you could call them the priests used to have a conversation with the gods about the demos, about the democracy, about the people. And I do want to just highlight, in this construction, the people is not quite the way that we use people today, because there was this other concept called the barbarians. The barbarians were the people who were not included within the jurisdiction. You can kind of imply there that, okay, so those who do not speak the law of the land are not included in the people of that land. This has been problematic and used to exclude people up till today, obviously. And I want to stay away from that idea as we move forward, because law is accessible to every human being, obviously. But it's important how this circle is made. As I said about Latour, the circle can get smaller, and the exclusion of human beings through this process of who speaks the law and who does not is very important. And so when we think about, well, what is in this circle, right? So the demos is definitely here, the people, the democracy, right? The people, the humans within the jurisdiction. But they're only here, quote unquote, right? Because you could be physically within the jurisdiction, but not recognized by the lawyers, not recognized by the government officials, and not recognized by other humans in the jurisdiction. So you're only 100% sure you're within the jurisdiction when you're within the institution of law, right? So you know you're subject to the jurisdiction of law when you're in court. You know you're able to use the law as an instrumentality to enforce your rights when you filed a lawsuit and you're in the process of court. And then, on the other hand, you kind of know whether you're in or not in with the jurisdiction based on what your ideas or your ideologies about law are. And this is where I think is, again, I think this is the most interesting part, is that people can be within the same time and space. They can be within the same area. They can be in the same room. And yet they can have very different ideas about what the law is. Now, this is based on our own experience, our material reality, our class, what economic system we've benefited from. In many ways, it's a construction of what we believe skin color or ethnicity or language to mean about our identity. And it's through our family structures, our religious structures, and our educational structures that we learn about these things. So when these things are combined, we have kind of an interesting mismatch of ideas about what it means to speak law. And so in some religious circles, there's this concept of Babel, which gets translated later in the Dutch to gibberish. But to this idea that if I don't understand what you're saying about the law, we are not speaking about the same law. I think you can make that same comparison to religion. If we say that we believe in the same God or the same gods, and yet we don't understand each other, we may not believe in the same God. And so we need to think about this construction of language and what we're really talking about with each other and how that plays out in these actual physical spaces. So within the Law and Society tradition, there is a book that looks at this kind of these dilemmas or these different viewpoints of the law in historical England. And this is, a few hundred years after the Magna Carta, which is kind of this really big document that people refer to. Although it's not very big, like long, it's quite short, but it's a very important document if you go to a law school class, or you can look up a documentary. Lots of folks talk about this process of law, which is putting restrictions on royalty, right? So those who had practiced power for a long time, being restricted in their use of power by their human beings. And this is this kind of idea that we want to try to start to think about, is the arbitrary and capricious use of power is limited by human beings who usually are not seen to have power. So this is a very interesting contradiction that we want to spend some time thinking about. And so you'll hear a lot from very intelligent people, and then from people who rarely think about this at all, who are still intelligent, that law is simply being used by the rich to hold poor people down. And I think you can find evidence of that in a lot of different places. However, this has not always been the case, and it is not always the case. And so I think we have to think about it in this historical sense, that during these 200 years that this individual is looking at, law was used as an instrument of conflict. So a place where people could argue and defend and enforce their beliefs and what they thought law was in a time and place. And so that complicates this idea that law can only be used to benefit the rich at the expense of the poor. So we start to see law as an instrument and a mediation or a negotiation that certainly is used to reinforce a certain set of power relations. And in this particular book, it's the use of law as a way to defend property, first against other powerful people. So people wanting to have different uses of a certain park, and in this time, this is the King's Park, right? And people that wanted to do some hunting and just different activities within this forest. But wealthy folks or rich folks or powerful people wanted to use that space in a different way. And so you kind of have this clash of uses in this field or in this forest. And you can start to see that's a jurisdiction, right? So they're speaking law about this place that's been kind of fenced off, and they want to kind of conflict it out. They want to see who's going to win here and what are the rules. And so you see a lot of ideas about, well, what does this mean? Why should I have a right? Why do you have a right? Should we share it? Who gets the first dibs or the first way of using it? And so what law becomes here, as in the negotiation process, is an explanation of why that person or why that group gets to use it this way. So we call that legitimation. In other words, in reality, if I use the law in a way against you, but you see that the process was fair, you see that the right is correct, and that someday maybe you want to use that same right. And so you might have thought that you were in the right, but then through this process of negotiation, you said, well, maybe I had a weaker position than I first thought. And maybe this other person who I wasn't thinking about at all has a better claim, or they have a better use, or it would benefit society more or the group. And so I'm willing to withdraw my complaint or withdraw my exercise of rights because I see that this has changed my mind on this idea. When that happens, what you're saying is that the process was legitimate. It was constructed in a fair way. you felt like you had a fair representation and that people were listening to you, but that you realized that you needed to change your mind for a variety of reasons. Now, when that doesn't happen, when the rules seem to be rigged, when there doesn't seem to be a good explanation, and when you still want to hold on to your claim because you think you have a better claim than other people, or at least as equal a claim, then that's not a legitimate process, and you're very unlikely to follow what the other people say. And most often in history, and in this time that Thompson is looking at, folks would resort to violence or the threat of violence when they saw the process as not being legitimate. And so you see here that the idea about law as a tool for different groups is based on this concept of fairness. When it is conceived as being fair, people are more likely to go along with the ultimate decision. But when it's seen as not being fair, people are more likely to resort to violence, to threat of violence or theft. And so there's this kind of, as he says, it's a central arena of conflict. It's a place that can resolve the conflict, but it's not necessarily going to. And this is because people are not as stupid as many so-called intelligent people think they are. And I love this line that's from the book. People are not mystified by the first man who puts on a wig. I think in this time period, you'd think of, we are not mystified because 9 people put robes on and, say things in the Supreme Court. This is not tricking us. We're not suddenly, oh, well, these are the gods of America. I think we understand they have power. We have some ideas about how they got their power. But that power has a limit. We're only willing to follow so much. And I think this is why you see in the last 2 or 3 Supreme Courts of the last 20, 30 years, 5-4 decisions, 5 people voting one way, 4 voting the other way, and each president kind of picking people who are more and more like what they think they want their voters to be. And so it's not a unified group of people, those people in power, and people have lots of different ideas about what they think other people want. And so the point here is that it's not a universal. There's not one monological idea about what law is or what power is. So, even when the rich are trying to take advantage of the poor through the use of law, they are still constricted or confined or reduced to using the forms of law. And when they do not, they still have to go through a process of law. So folks who did not think that the President Trump was using his power correctly brought a legal case against him in Congress. And so regardless of what the outcome of the trial is and was, it's more about the form, right? So people, even when they want to violate the law, push the law to its boundaries, President Obama kind of did the same thing with immigration and with the war on terror, are still being judged, or they're still being analyzed, and they still have to negotiate with others through the process and forms of law. So this is just like any other institution, or not any other institution, but certain institutions, such as the media, the exchange of information, certain religious cultures, that they have their own way of thinking about things. They have their own members, and those members act in very different ways than other institutions. But that each of these institutions, whether it's religion, whether it's economics, whether it's the media, or whether it's the law, whether it's science, right? They have their own independent history, right? They have historians, people who write about the law. In the English law system, you have the Blackstone's commentaries on law, for example. But they also have their own logic of evolution, meaning that the back and forth that happens within the institution forms this process of change. And so this is what we're going to be focusing on in the rest of this presentation, is what is this logic of evolution? How do things change? And how is law used as a tool for change for groups? So we want to make sure we understand there's a big difference between the arbitrary use of power, just doing whatever I want, whenever I want, however I want, or getting what I want, how I get what I want, who gets what they want, right? That's a kind of older concept of power in political science, and the rule of law, this kind of process or this central arena of conflict that mediates and distributes uses of power in very different ways that are very different than I just get what I want and it's just kind of this free-for-all. So we want to start thinking about the language of law as a construct, or the construction of law as a tool, meaning groups construct, they conceive, they build, they design, they talk about, they write down, they use law as a tool to get what they want, for justice in their whatever they mean by that, to remedy injustice, some wrong they think has happened, they want to make it right. And so law is a tool in this case that they're using in order to resolve some conflict. So yes, the powerful use the law to their advantage. I don't know too many people who would say that's not true. And the effect can be to control or dominate the powerless. Again, we could find a lot of examples of this. But the powerless, historically, have resisted domination and control through the use of that same law as a limit to the use of power by the powerful. Now, this might seem obvious, but we need to think about it for a second. So, in sum, A, the powerful definitely use their law, their ideas of law and law as a tool against B, the powerless. But B has resisted and used that same law to push back against A. So this creates this kind of world called C, right? This other thing, A plus B equals C. And so here's this C that's kind of creating this structure or jurisdiction. There's a lot of different ways of thinking about this. And I can almost think about it as a circle that's moving, right? That's spinning, almost like a merry-go-round. And so A and B are in this kind of conflict of words or conflict of tools of law, but there's something else going on there. And so both A and B are changed in this conflict, and then law changes as well because it gets identified as what are the rules that each side are willing to follow. And so you kind of see it as kind of almost this back and forth or this kind of narrowing or lots of different ways, again, of thinking about this. But that makes sense when we think of law as a tool as opposed to some object or something that's out there. Instead, it's this thing that people are using in order to try to benefit their group. So if we apply this to a situation, we look at the Scott versus Sanford case, where the Supreme Court said that folks of African American or African history, or those who have a nationality outside of the United States, and in this particular moment before the Civil War in the 1800s, if they didn't come from England, you can see that here the ruling class, the dominant group, the majority, are using law as a tool to justify their exclusion of people of African descent. So we use the same logic we were talking about before. A is using law to dominate, control, or oppress B. Again, I don't think there's anyone who would really disagree with this, and even the Supreme Court, I think, makes it very clear that this is what they think is going on. But on the other hand, Scott, B, is using that same law. And what's interesting in that particular case to me is that he's using this ancient concept of the rule of law, that same Magna Carta principle of habeas corpus. So he's saying I have a right as a person to resist oppression, establish my right to privacy. I can define life, liberty, and pursuit of happiness for my family. And it's a very complicated series of cases that lead up to the Supreme Court, in which a large number of people are in fact arguing about what do they think law means in this case. And so you say if it was just A using law to control B, there wouldn't be an argument. There wouldn't be a way of thinking about this other than, well, I'm going to do whatever I want. It's arbitrary and capricious. But because law has been defined through its history and people have different ideas then about what they think life, liberty, and the pursuit of happiness is, then B, Scott uses that to his advantage, and he gets his case into the courts. Now, again, it doesn't really matter at this point what the Supreme Court decides, because the idea has been let out, and now C, the other people who are watching what's going on in A and B, and these are members from the group A and B, right? These are members from the powerful and the powerless. They're learning about this idea that law changes meaning and that they can use the law how they want, and so therefore they can change the law. And so the language of law evolves with humans because B is using that same law, the way that A was using it, to resist A's control. So to review this set of principles or these ideas, we start with this basic idea of power, control over others. This is to dominate other people. And you hear people talk about this quite a bit. I've got the power. But then there's this other idea of power, which is the strategies of resistance. And there's a lot of reading that you can do about this, but probably most famously Michel Foucault, a philosopher from France, and then also Patricia Hill Collins here in the United States have talked about this a lot, of what do these strategies of resistance look like. And the famous examples I think you could think of are the civil rights movement, the women's suffrage movement, just groups of people saying, well, I'm going to resist this idea of control over me. And then that means that the combination of these two powers, right, the control and the resistance, create this new third power, the power to create an arrangement of sharing this burden that we go through in life, right? I think people often forget this idea, right? But behind these uses of power is a structure of economic production, right? How to build houses, how to grow food, how to slaughter animals to eat them. I mean, there's this other thing going on, which is all about the burden of existing, of living our life. And in a certain economic arrangement, control over others makes sense, right? This is why people are doing it. In different economic arrangements, people start to learn, well, I can resist that control because I don't believe in that economic arrangement. I don't think that it has to be that way. So you see people are using power in this sense to kind of justify their own positions, but also the larger kind of social burden that we're living in. And this is where law really starts to be clearer, I think, because depending on how you see power, you're going to see law differently. So if you see power 1 as control over others, then law 1 equals rules to control others, right? These are the rules that people are using to control people. So I think of stop and frisk, for example. Police officers are using stop and frisk to control other people because that's the power dynamic that they're aware of. They become aware of when they see the strategy of resistance, when folks start using lawyers to fight that idea of control. And again, they're doing it on that basic ancient idea of habeas corpus. So here you see this concept of rights comes in. So, well, no, I have rights to limit how you control me or how you try to dominate me, and I have access to those same rules. So you have to follow those rules too, power 1. And so you see law 2 comes in with power 2. They come in together. And so if you start to see that this is all a negotiation between groups or among different groups, and we're all trying to share the burden of existence, then you see now we have a constitution of minds. We call this law as the constitutive order, right? This is the field of relations or the network of relationships where we make these tools in order to try to figure out what is this balance, or sometimes what is the imbalance, right, of how we're going to share this burden and what rules should we construct together in order to follow them, and should those change and how should they change? A lot of very complicated questions. And the idea here is to see that law is not a simple linear process. It's not just one thing that goes on through time and space, but that it's a complicated thing that we can reduce, or I guess not even really reduce, further complicate into 3 dimensions of power, which then have 3 corresponding dimensions of law, or the use of law as a tool. So in the last two ideas, I really just want to kind of concretely come back to this then. So I want to use some examples here. So language is a tool too, right? And so law is a language that's being used as a tool. So tool for what? Well, tool to act. And so here we have the basic idea of social justice, right? Again, I might even move to the second bullet point there. So justice cannot mean the same thing to everyone. That's why we add social to justice, right? Social justice could mean rights enforcement. Right? You've done something to my social group, and I want to exercise my rights against you. I'm going to hold you accountable for this wrong thing you did to me. On the other hand, social justice can mean, as a group of people who've been excluded from a political process, I'm going to use law to get access to that process. And that's a very different thing. And then I think, further it could mean social justice could mean something like food justice or environmental justice, economic justice, right? Justice being something that's being defined by a group of people, and then they're using the law as a tool to advance their cause, to get justice within that rules and procedures and the rules of the quote-unquote game of law. So people are constructing a language to match the language of law. So they're kind of bringing the languages together in order to advocate or advance what they need to live their lives. So here you start to see then there's choices of inclusion and exclusion. And I am not claiming that these are simple. In fact, I'm claiming, that they're rather complicated. So if you look at something like white supremacy, the history and language of exclusion cannot be reduced to just 2020 or 2016. And I very frustrated, I think, a lot of times in the political conversations, in the media conversations, and often even in classrooms, where folks are trying to reduce something like white supremacy or domination to one time period that could only have existed then. These processes have long histories, and language is used in very different ways. And even when we start to compare one side, right, one side of this dynamic, so the control over other people in 2016, to say the control over people in 1936 and the Nazi Revolution, I think you start to see, at least now, well, this means that there must be some process that goes before 1936. And so you see law and power being used even in Machiavelli's times, in 300 years before in Italy as, fear and dominance. And then you can kind of just keep going back and saying, okay, there's a line of tradition here in which folks are using the concepts and language of law to exclude other people that goes back a long time. And if you recall at the beginning of this presentation, I talked about that concept of barbarian, and that's where this kind of comes in very clearly here. I can use language as a tool to exclude a group of people and say that they are not subject to the jurisdiction of the law. Now, what gets difficult about this is the case of global migration. When folks are being excluded from that law, we're saying that they don't get any rights. But on the other hand, they're saying when you come into the jurisdiction as a physical place, I'm going to use the law to exclude you. That's a contradiction that cannot be resolved. In other words, it cannot be resolved through the law. So I'm arguing here that when language is a tool that is using law to exclude other people, it is being used in a contradictory way that cannot be resolved. So we have to go back to the concept of inclusion, and here I'm borrowing heavily from Dr. Martin Luther King Jr. And St. Augustine. We have to think of that circle as an increasing circle that brings more and more people into this conflict of what rights mean, of what law means, and really what language means as an action. And so when we do that, we provide a space in which conflicts can be resolved through the forms of law. Now, there's lots of problems with this, and I acknowledge that. Who has access to the law or the rules or the spaces, right, is a big deal. Who can afford these processes is a big deal. What are the interests behind the individuals and groups that are trying to use this? Is this for environmental safety? Is this for food equity, right? Just being able to eat good food? Is this about education? There's so many different conflicts and problems that exist that we'd have to think about very carefully as we construct the organization of the rules of law, and we need to do this through a language of inclusion. Is what I'm trying to get at. When we exclude, we make it impossible to resolve this conflict. When we include, we have a possibility. We have a dialogue that's forming that can start to think about law in this way. So there's a lot of examples and explanations from the Law and Identity Reader. In fact, my co-author Helen Margaret Nasser and I went to a lot of trouble to make sure that we had as many different examples as we could come up with in the time that we had. I think the big ones you can see are the spaces that talk about reproductive rights. when folks are excluding people from that, then you have a one-sided view of what a reproductive right is. And I think when you start to think about the quote-unquote political debate as pro-choice or pro-life, you see the problem here, right? Pro means that somebody else is being excluded from what I even get to talk about. It's frustrating, I think, in that sense, because when we're thinking about language as a tool, well, you see what's going on there. I'm using language as a tool to say, well, you're not pro-life. Well, that's a very odd phrase, and so it's clearly something that's been constructed within a group. So how can I even know what you're talking about if you've never talked to me about it? And I think that's one place where we could start to think, okay, let's think inclusively here. Let's think about rights. Let's think about law as a tool for conflict resolution. What language can we construct together where people are talking about reproductive rights? You certainly can talk about the limitations of those rights, but I think you'll start to see, well, there needs to be an ethic of care. There needs to be a human concern. If you're quote-unquote pro-life, what are you doing to support the children of the world, and not just this hypothetical child that you only seem to care about in a debate? On the other hand, if you're talking about reproductive rights as, again, a hypothetical right that you might want to exercise someday in the future, what are you doing to safeguard against rape, sexual assault, incest, right? These other conflicts that might not be concrete and right in your world today. So, I think when we start thinking only as like this hypothetical thing, we run into a lot of trouble, and it's very easy to exclude. So we have to make choices about inclusion that are ways that we can talk with each other about actually all of these problems, which means you're going to have to include a lot of points of view. So in our class, our examples and explanations have come from complicated conversations about how land is used in New York City. And we saw that the language around who lives where is not inclusive. It's very exclusive. And the example that we were looking at, several examples we were looking at, had a category, a language that said non-Hispanic whites. And there was a percentage based on each geographical location on a map about who lives there and who doesn't live there. And so entire groups of folks, beyond just that very odd construct of race, are being excluded, right? We're not looking at religious beliefs. We're not looking at economic advantage. We're not looking at children, like whether you have children or not, right? We're not looking at access to healthcare. All these other things that have to do with our everyday lives, we're not even thinking about. We're simply looking at this one category on this map and saying, okay, how can we change New York City based on this concept? And so this sociological term gentrification comes in. Well, sure, there is a process by which people are trying to move other people out, holding down the value of the land until they can redevelop it for other people. But again, that's excluding a whole other list of things that are going on in that same area. And so we want to try to think about language as a tool that can bring as many people into the conversation as possible, so that we can start to use law as a tool for conflict resolution, not for simply putting people out of the jurisdiction. So I just want to offer a graphic to try to think about what we've talked about in this presentation in very concrete ways. So I have a very abstract picture on the bottom that says, okay, this is how we started. There's this kind of interesting, weird circle that goes through time and space and different uses of law. The law being the place and the rules and all these things that we've been talking about in this conversation. And so we just take these three categories: institution, instrumentalities, and ideologies, and I tried to break it down into red, blue, and green just so you could see there's a flow, right? So within the institution of law, we're talking about the organization of the rules and the procedures within that place. Okay, it could be court, it could be a law firm, it could be a religious organization, it could be a business, right? Each kind of place uses the law as an institution to organize their rules and their procedures. Even little children do this on, the playground. I say they're playing tag, and they say, "Well, you broke the rules," right? Well, So then they have to talk about, well, what are these rules and how do I proceed, right? TAG, I think, is a pretty great example of that. Within the institution, then, there are roles for the actors, for the people within that network, right? So lawyers play different roles. They are different actors, right? You have plaintiffs, defendants, judges, juries, all these different roles within this network of law. Then you can start to think of the rules of the game, right? The game not meaning the game of life, but the game of that institution or that place, right? So the rules of the courtroom. Sometimes it's called decorum, right? How people are supposed to act or behave within that place. The rules of street interactions with police officers. The rules of filing a appeal for your grade if you don't like what your professor gave you. And there's some basis to do that, right? Those are the rules of the game. What are the rules? How do I know whether I can appeal a grade, right? So this is within the institution of law, right? So you'll have to look at the organization of rules and procedures. By the way, in that particular case, it's the student handbook. But again, you also want to look at the faculty handbook. And then there's administrative rules and procedures, right? So within the institution of law, it's going to change depending on what place you're in, okay? And so I want 3 words to kind of stick in your mind. We're talking about, as the law is an institution, we're talking about authority, right? Some in that A has power over B, but B can resist the power of A. We're talking about authority. We're saying, what is the legitimacy of the decision that's being made? And if it's fair, and we perceive it to be fair, and the more people and groups that perceive it to be fair, the more likely there's going to be legitimacy of authority. Connected to that, right, the relationship there is the instrumentalities of that institution or of the law. So if the institution is talking about the organization of rules and procedures, here we're talking about the tools within that organization. So I learn the rules, I learn what the procedures are, I know what the process is now. Now I have to access and use those tools. So it could be a lawsuit, it could be a complaint, right? It could be filling out a form, it could be going and talking to a lawyer, it could be, there's all these things, forming a dialogue, mediation. There's so many different tools to access now. But again, those are particular to the organization. Then there's the methods to follow for the actors, right? So once I kind of know what my role is within the network, now there's a method I follow, right? So the tool, let's say it's a lawsuit, there's a method, there's a way of filling out that paperwork. Okay, so I have to then learn that. Then I have to see the form of the rules, right? So here I always think about the laws of evidence, right? What gets into a courtroom and what doesn't is not just based on who's bringing the evidence, right? That's the role, the actor. It's not just about did they fill out the form correctly, but it's also did they understand the form of those rules? In other words, did they understand what makes something materially relevant? What makes something hearsay, right? Can they understand the debate that people will have about what makes something tend to show a fact about what something happened? And they have to think about, well, what is the judge going to say? What is the jury going to say? What are the other lawyers going to say, right? What is my social group going to think about this? So I have to think about the form of the rules. What are those rules intending to do? What are the consequences of those rules? And how am I using them? So I think about this as a process. And it's a process to resolve conflicts, so resolution. And there's always some kind of form of judgment, right? We talked about it could be social groups, it could be a judge, it could be a jury, right? There's different roles and different actors that are going to form a judgment. Okay? I see these two things as really being interacting with ideology kind of all the time, right? And ideology are these ideas that we share with other people. So this is based in our mental model formed with the context we have within the institution of law, right? So I want to try to make sure everybody understands this idea, right? So I start to have ideas based on my interactions or contacts with lawyers, with lawsuits, with laws that I read online, with legal situations, right? A car accident. I think, well, who's to blame here, right? With did I follow the rules of attendance when I was in kindergarten? All these different structures of rules and organization of rules and procedures tell me how to think, right? And I might change that a little bit. They don't tell me how to think, right? I learn how to think based on the interaction with these rules and procedures. And in this environment, then, while we're learning about, how to think about the rules and the procedures and the forms, we talk to each other. We watch each other. We see who gets in trouble, who doesn't get in trouble. We see, well, that person succeeded in their lawsuit, so maybe I might try. Or we say, well, that person, didn't win the lawsuit, but look at all the other things they were able to organize in that process. So we share these ideas with other people, and that helps us kind of form our beliefs about, are the rules in the form of the game fair? Right? Are they legitimate? Should I trust this authority? Is the process good to resolve conflicts? So now we're making judgments about the judgments. This really goes to this kind of core belief system that seems to be in the narrative or the story about the United States and the legal system, that people are responsible, right? And I don't want to dwell too much on individual responsibility. I think there's lots of great readings and debates you can go on and on and on about whether that's real or whether that's something that we should even care about. But there is clearly within individual responsibility, because otherwise you're responsible to yourself only, right? And that doesn't really make any sense. Certainly you are responsible for your actions. But responsible to whom, right? And so obviously to other people. When you go outside, there's other people out there. And I just, I'll use two quick examples just to show that this is not generational. I could easily start with the example of saying when people are on their magic computer boxes called smartphones, right? And they're walking down the street or they're in a public space and they run into someone or they nearly run into someone. They're clearly not understanding that they're responsible for their actions within a social space. The same thing can happen, however, with older folks when they have an umbrella, right, and it's raining outside. Sometimes they seem to believe that they're the only people on the street. So again, it's not so much like I'm responsible for myself. Well, no kidding, right? I mean, I'm responsible for using my phone. I'm responsible for using my umbrella. Yes, of course. Who else is going to do it for you? But on the other hand, right, I'm responsible to and with all these other human beings. And so this can get very complicated, of course. But we wouldn't have created the structure of law with these tools to follow and all these different roles if responsibility was simply something you did on your own, right? It's that kind of idea that leads to the conflict. And so this is a place where we're trying to, what does responsibility mean within this language of law? This also is true of liberty, right? So of course you have freedom. Of course you have the right to pursue your own happiness. On the other hand, you have to think about, well, what is the limitation of that? I can't just arbitrarily do that to take it away from other people, right? Or at least that's what we think we're talking about when we're talking about the process of fairness and authority within the legal system. And so what does it mean to be free? What is liberty? What is privacy, right? What are rights? How do we understand this within this structure? Understanding that some people are trying to dominate. Some people are trying to resist. Some people are trying to create spaces where people can get along. And so we have to start thinking about ideologies as this very complicated structure of relationships in which we talk about the ideas of what these words mean. And so law is one place, one institution where this is happening. This is also happening, like I said, in the workplace. It's also happening in religious institutions, in your family, right? In relationships, on TV, right? But we're looking at the interrelationship of institutions, instrumentalities, and ideologies as it relates to law as a tool for social groups in the pursuit of social justice as it means to their group.